One of the final aspect in understanding contractual liability on indemnity is to understand the fact that while indemnity is viewed as an alternate to damages, one should understand that the cases in India and in other countries and jurisdictions have said that a lot of similarities does exist between damages and indemnity. However, indemnity is different from damages for a couple of reasons. And one of them is that when can indemnity commence, or when does then indemnity liability commence in a contract? Usually, when you see it as an extension of a new form of damage, then you will probably come to this conclusion that indemnity only arises when a loss is made, or when there is a recovery of dues, or when there is some kind of damage or proof of the same. So unless someone has suffered a loss, indemnity will not come into existence. This is a kind of understanding that most of us have when we read indemnity along with damages. However, the slight distinction over here is indemnity can commence as soon as the amount of indemnity is confirmed. When the liability is certain, and it's not that the liability has to be absolute, or it is not saying that okay, let's assess the liability finally and only then indemnity will commence. So once the liability is certain, once you know precisely where you require indemnity, and if that amount is kind of certain in terms of the actual loss, then the indemnifier's liability commences, right? So it is important that you should understand that indemnity is not always to cover your loss. Of course it is, but once the loss is absolute, certain and imminent, then indemnity should commence. So you cannot wait for or postpone your remedy to claim indemnity after an assessment of actual or total loss. So indemnity can even start as a contractual obligation right from the time the contract is made. So you don't necessarily wait for indemnity for an actual breach of contract. You don't wait for indemnity for the damages to be total, absolute in terms of the final figure or amount, and then you do not want it in terms of the proof or actual loss. The obligation on indemnity can commence at any given point of time as soon as there is an absoluteness and certainty and imminency of loss. So that's what was stated in this Bombay High Court case of Gajanan Moreshwara versus Moreshwara Madan Mantri. And it's a very important aspect of the distinction about indemnity as well as the kind of compensation or damages that you can actually seek in a contract, right? So I think when we talk of damages, we say it's one of the aspects of remedies in contract, and damages is usually a remedies for breach of contract. Now, the obligation of indemnity is something, friends, that commences even before breach. That's something that we have to understand. So it's not some kind of a remedy only after breach. It can even commence before the actual breach of contract takes place. And it means that you have a duty to indemnify, you have a duty to hold the person harmless, you have a duty to compensate a person as soon as he presents that kind of claim, and that this is in absolute terms some kind of an obligation that you need to actually indemnify the other person. So it's not remedies post breach of contract, or is not conditioned on a breach itself. It's a duty and an obligation to compensate, reimburse, to hold the other person as being harmless, to ensure that the other person does not continue to suffer any other loss or any other damage. That is when indemnity can definitely creep in. So I think the point of takeaway from this case is indemnity is a contractual obligation. It commences during the contract, and it is not some kind of remedy post breach of contract. Though yes, it is. I think indemnity will be used also to assess the kind of loss, but the duty to indemnify commences even before the actual breach of contract takes place. Finally, when you look at indemnity, friends, under insurance, we always say that to cover indemnity, you always take an insurance policy. And I've given you a couple of examples of how the risk of indemnity or the anticipated loss of indemnity is covered through the insurance scheme. However, you have to note that there are several kinds of indemnities that one seeks for in terms of the kind of loss or damage one occurs. So we always say that while indemnity is kind of insurance, but all insurance policies are not indemnity, especially life insurance, because you can't actually assess the loss of life in terms of a monetary compensation. So the loss of life is not equated to what has been promised in the insurance, right? It can be more than that, it can be less than that. So it is just a coverage of risk. Though indemnity actually is something that should compensate you in monetary terms, the kind of loss that you have occurred, life insurance unfortunately does not do that. So other forms of insurance were considered as an indemnity kind of a contract. Broadly, above and beyond 124, please note that, right? So what are the rights of an indemnity holder? I think this is critical and this is very, very important. If you read the law under section 125, you will notice that an indemnity holder, right, to whom a promise of indemnity has been made, can actually recover a couple of things. First, he can recover all the kind of damages that he has occurred or he has to pay in a suit. So in a case that is filed against an indemnity holder, if he has to pay some kind of damages, then he can recover all that. This is point number one. So, this clearly says that because of your fault, if I face a litigation, anything that incurs in that litigation, you are responsible to indemnify. Second, in defending the suit or in bringing a suit, so there are two ways. So, you can bring, you can defend any kind of cost or sum that is incurred in doing the same, including legal fees and legal cost or any kind of cost can also be claimed under indemnity, right? So this is what the law says, but broadly you will understand that contractual clauses can even say beyond it, and you will notice that any kind of damages in a suit or all costs that you have to defend can still be considered as some form of direct loss. But as I told you in the past, indemnity contractually can also go beyond the direct loss and also cover consequential damages, which are indirect damages, and which we will talk a little later. Now, the Indian law on damages does not permit you to claim consequential losses. You can only claim direct damages, which are reasonable in nature, which can be foreseen, and which have a natural consequences to the breach of contract and which are not very remote to the breach of contract. However, indemnity probably provides you that kind of discretion to get all other forms which damages actually cannot give to you. So friends, I think I have emphasized adequately enough of the role of indemnity in contracts, in modern day contracts. And I think every kind of a government tender or a government agreement must have a robust indemnity clause, and it should be mutual. I insist upon that. For the simple reason is that you cannot expect the contractor alone to indemnify you for every kind of a loss or a damage that the government occurs due to his actions. I think vice versa. I think the government must also hold him harmless and also compensate him in case he suffers an injury for the government's actions, acts, or omissions. Which may include, several other factors. Like, for example, if a contractor has to be given a land for construction or doing a works contract, if there is delay, and due to the delay of handing over the land, the contractor suffers any kind of a loss or injury, or because of the construction work on a land, the villagers actually assault, attack a contractor, and he suffers losses or his employee suffers any kind of an injury. In those circumstances, the government owes an obligation to indemnify as well. So that's how the mutuality principle under indemnity should be used or operated, and I think that's an important aspect that one needs to imbibe into contractual obligations. And I think this becomes a very critical clause about what indemnity can cover and what it cannot cover. What are the grounds? Can it cover natural factors? Can it cover human factors? Can it cover accidents? As I told you, these are three important categorizations of how an indemnity clause may have to be drafted, right? So taking the clue on that, I think we should now move on to another form of contract, and that is contract of guarantee.